Layshock versus Hermitage School District.
Denise DeGroat.
Alicia Gardner.
Ryan Schreiner.
Meet Justin Layshock. He was a senior at Hickory High School in the Hermitage School District in Pennsylvania. This is Principal Eric Trush, Justin Layshock's principal at Hickory High School in the Hermitage School District in Pennsylvania. Justin Layshock created a parody MySpace profile with his principal's picture, which he downloaded from the school website. Mr. Layshock created this MySpace account as if he were his principal, Eric Trush, off campus and on Layshock's grandmother's computer during non-school hours. The account had bogus answers that referred to large or big due to the fact that Mr. Trush is a large man. They also contained derogatory terms referred to alcohol and drug use and homosexuality. The student body learned of the parody site and got online to access it while at school. In fact, 3 other students created other accounts which were worse than Justin's, prompted and spurred by his parody. Once the district found out about the MySpace account, the superintendent, Karen Iota, met with Justin and his parents, Cheryl and Donald Layshock. His parents were very angry with him and grounded him from his computer when Justin admitted to the incident during this interaction. Then, without prompting from anyone, he apologized to the principal the next day. Justin was not disciplined at the time of this meeting. However, the following week, the family received a letter that stated they had to attend a hearing based on the incident that Justin admitted to in the earlier week. At this hearing, Justin Layshock was found guilty, and it was decided Justin would be suspended for 10 days. He was then given the opportunity to attend school, but only in the alternative school setting. The school also denied him access to extracurricular activities, and he was not to be allowed to walk across the stage during graduation. Justin and his parents filed suit citing free speech and due process violations. The school district stated it was supported by Bethel versus Frazier because the MySpace profile was unquestionably vulgar, lewd, and offensive, and therefore not shielded by the First Amendment because it ended up inside the school community. The district also felt their decision was warranted because they felt Justin entered the school when he accessed the website. Thus, he was on school grounds when he created the profile.
Were Justin Layshock's First Amendment rights violated when the school punished him for his actions that took place outside of school hours and property? Unanimous decision in favor of the plaintiff, Justin Layshock. Yes, Justin's First Amendment rights were violated because the school cannot stretch its authority into someone's home.
A main point is the fear of setting a precedent for schools to discipline students for off-campus behavior. Judge Theodore McKee said, "It would be an unseemly and dangerous precedent to allow the state, in the guise of school authorities, to reach into a child's home and control his or her actions there to the same extent that it can control that child when he or she participates in school-sponsored activities." There was not a dissenting opinion for this case.
I believe that the courts made the right decision in this case concerning the issue of schools and the extent of the authority they have. For the courts to go the opposite way, it would have opened up a lot of problems for students in the future. Schools would have too much control over what students can or cannot do outside of their jurisdiction. However, I do believe that the principal who was mocked and made fun of on MySpace should not have had to endure online slander. He also has rights as a person and shouldn't have lewd or offensive things said about him online. For the courts, the decision comes down to whose rights are you going to protect. Overall, I do agree with the court's decision on this case. If they had ruled in favor of the school, it would have put too much power into the hands of the school. The implications of an opposite court ruling would have been monumental in the amount of power given to schools and how far their discipline can reach.
The decision pertaining to education keeps its power in check. It would give too much power to the school if the judges had decided to vote in favor of them. Their authority would extend into the homes, local playgrounds, and grocery stores, which none of them are classrooms. It prevents their authority from reaching these places, and it should. Schools have authority inside of the classroom walls and not the homes of children. The First Amendment rights of the students need to stay intact. The Supreme Court didn't have a significant reason to hear the case, nor did they have the authority to make a decision, since they didn't want to take part in a potential monumental hearing. They felt it was the best way to leave education up to its constitutional authority figure, the states, so it was important to leave the decision up to the previous court. Children would have been more fearful of enjoying their childhood. They would have not been able to exercise their freedoms of the First Amendment as readily as they would with extended power for the schools. I don't know if education is necessarily prepared to set such parameters for off-campus behavior, since schools are having a difficult time enough disciplining students inside the classroom walls.
I believe the courts made the right decision by not allowing the schools to extend authority off campus. I can see an infraction based upon his creating something that he accessed while he was on school campus. However, if the courts had sided with the school, it would have led to bigger issues, with schools being able to punish kids for their First Amendment rights that they are exercising at home. On the other hand, the principal was being subjected to slander and embarrassment from the crude and very inappropriate MySpace accounts that were created. I'm sure it distressed him in not only his professional life, but also his personal life, especially since he had a high school daughter who saw the site. Yet, I believe the principal and district should have handled the situation differently. I think they laid out a punishment which seems arbitrary and greater than the extent of the infraction. Plus, there were 3 others who created even more offensive accounts of the principal, and they did nothing to punish these individuals. Are they not held to the same standard? Are they not all students at the Hermitage School District, where they cited the discipline code violations? Therefore, it seemed as though the school was just trying to make an example out of Justin. And the more I researched the case, the more it seemed to grow, and I truly believe it was ego and emotions that carried it into the courtrooms.